Bobby, whoa, you are discrediting Hytmiah. He kept everything except for $500 and a pound of marijuana.
That is true.
He so graciously gave to Darby, who is, again, not even the man that they are trying to get the proceeds from, in this case, Elias. He gave it to Darby.
Right.
So look, he's not completely selfish.
Right.
He's just a little selfish.
I don't know. Maybe if there was actually 400,000 in the house, as they thought, maybe Elias would get a cut. But no, I mean, he will get none of that.
How much pot was in the house? Like pounds?
So I don't know. I'm not an expert on valuing marijuana. However, if 17 defendants were arrested and his cut was 10,000, I would assume it was probably a lot.
In the year of our Lord 2025, discussing marijuana charges, I mean, obviously armed robbery is another completely other situation, but it does make it a little less serious when you start getting into, there was marijuana and this and that and the other thing, and you think there are people in Colorado doing startups absolutely selling marijuana.
A special guest discusses a speedy trial that actually was not so speedy, and then a marijuana and cash heist that goes about as well as you would expect a marijuana and cash heist to go. This week, here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, November 4th, 2025. And yes, we are very excited to have a special guest here this week. We're going to talk about what she has to say about the law in general, and also about this case out of the Fifth Circuit involving some incredibly bad things that happen in the justice system in Mississippi. Then we're going to go to this case that's about stealing marijuana and cash, but really about forfeiture and criminal forfeiture versus civil forfeiture. But first, I'm going to introduce who we'll talk to later in the show, and that is Bobbi Taylor, my colleague at IJ. So Bobbi's going to be discussing this Second Circuit case about forfeiture. But I just reached out to her to come on the show because we had show coming up and we have this special guest on, and I had no idea, who she follows online. But it turns out that for Bobbi, part of what got her through law school was watching our special guest. So Bobbi, tell us a little bit about this.
Yes, that is true. Reb, I found you, I think I was a 2L. You were studying for the bar. I was taking evidence, and I have probably still on my phone somewhere a big poster board screenshot of all of your evidence notes that I sent around to my section. We're all very grateful. And I just kind of followed from there. So I told Anthony, come for the study tips and stay for the humorous content. So I appreciate it.
Absolutely. I am so happy not only that could help more than just me, right? Yelling into the void about, my conspiracy theory boards. I'm shaking from overconsumption of coffee. Like, you guys, I swear, this is the way to do it. You need a visual. You need to visualize all of evidence. Freaking out, not only just to help people, but also helping a woman in law, helping other law students who definitely, I hope to be the help that I didn't have. So I'm jazzed. And I'm glad that you got a few laughs out of me, too.
Well, as you heard from Bobbi, our special guest is Reb Masel. She is a lawyer in California. She's been practicing for a few years now, but I gather very early in your legal career and studying for the bar, in fact, you started doing what we started doing at Short Circuit many years ago, which is just shouting about law into the void, hoping someone would hear you. Turns out a lot of people liked what you have to hear. So you started on TikTok and then kind of went from there. Now you have basically a video empire of all these videos about all kinds of legal stuff, including a few weeks ago on a matter we were involved with when we had that amicus brief from The Onion a few years ago. And you even have a book coming out soon. So, Reb, tell us a little bit more about yourself and like how you got into this shouting about law business.
Yeah, so I went into law school not only without a legal background, but without anyone in my family connected to the law, lawyers. I don't have a single doctor in my family. I don't have a single lawyer in my family. My dad's a basketball coach. My mom's a stay-at-home mom. They basically just waved and said, best of luck, right? We have no idea how to help you, help yourself. And that kind of ability to go into law school with genuinely the most blank slate of a mind with respect to this profession, how to make connections, what to do, what not to do. I just basically relied entirely on I'm good at school. I'm just going to do that, right? I'm just going to get back to my roots and do my flashcards and my visual study boards and hope it works out. And it did work out really well for me. I finished in the top of my class. I got to extern in the Central District of California. That was an incredible opportunity. I did moot court, I did law review, the whole shebang. And the one thing that I got out of it the most was, wow, there's so much that regular people don't know about the most interesting aspects of the law that are never covered in true crime podcasts about, the Ted Bundys and the John Wayne Gacy's. If you're an attorney in truly any area of law, but I would say specifically family law, which I am not, I do not practice, God bless, you know that the most interesting cases and things that happen in courtrooms very rarely involve murder. They very rarely involve the high-profile, sexy trials that you see covered online. And all I wanted to do was present it in a way that was accessible and entertaining, but also to keep regular people informed. I did it as a hobby entirely on TikTok. With my sister is younger than me. She told me that I was too old, that I was washed up, that I needed to get on TikTok. I needed to download the app. And it was COVID at this time because I took the bar in 2020, a great year to graduate and take the bar. And so I was living with her, right? We were all my entire family quarantining together, and I had no choice but to learn an 8-count dance with her to bond and post my silly little videos online to cope with the stress of studying for the bar. And now, 5 years later, I am so grateful to her. I owe her a lot. I owe that community a lot because I think that putting a spotlight on the law, whether it be the most interesting aspects of it, the funniest aspects of it, or the most horrific aspects of it, the aspects of it that are shielded a lot, in the media, or just, by want of information, or by the fact people don't have access to court records as easily and readily as I believe they should. I really have been really blessed to have a platform that I do, and hopefully will continue to keep the law fun while also informing people of things that I think we should be teaching everyone in K through 12 schools.
Well, yeah, shout out about how you talk about family law, but God bless you don't do family law, because that's always something I've found is that, my God, you need family law, but I do not feel that I could do that. When I was a clerk for a judge, the most awful opinions to write was general. We got all kinds of cases, and the most awful opinions to write were family law ones. So.
And it's just like two parents who hate each other more than they love their children over and over and over again. I couldn't do it. So God bless anyone who's a family law attorney or works in that sector, even some estate planning situations where you have to deal with family issues. Those people are saints, yes. I think.
I'm actually writing about a case right now, a family law case, estate case that went for 30 years. Different generations fighting over money. So
the Anna Nicole case.
No, it's not that one.
Wow.
A little older than that one. So, because you don't do family law or estate law, we're going to instead go to a happier subject, which is pretrial detention, where this fellow went through many years, many different judges, many different lawyers before even getting to trial, and it was all over some moonshine on a few bullets.
Right, which you can typically find in a rural county in Mississippi, I think. I think that's a very safe American pastime for most people around that area. Brian Berryman versus Huffman, this opinion came out October 16, 2025. And procedurally, this case was an appeal of a district court's denial of a habeas petition. But it originates from a state court case, specifically Brian Berryman had filed 4 pro se motions to dismiss his indictment based on a denial of his Sixth Amendment right to a speedy trial, which in the criminal system is not just a Hail Mary. It's a Hail Mary you throw with 2 broken arms and a blindfold on. Speedy trial violations are so rarely found. And even if judges dance around the idea of unnecessary delays in the adjudication of someone's criminal trial, the likelihood of getting any counts of your indictment dismissed based on a speedy trial violation is extremely low. In this case, however, which the facts of I'll get to in a second, all right, moonshine and trailers and good old-fashioned shooting, the trial judge had granted Brian Berryman's motion to dismiss 1 count of the 2-count indictment, but let the 2nd count stand. He appealed that. Appeal was denied, so he filed a habeas petition in federal court. The Northern District of Mississippi denied that petition, and it went up to the Fifth Circuit. Now, the facts of what landed our boy Berryman here in the first place are this. On February 6, 2017, as Short Circuit's newsletter already put it so succinctly, a few fellas were drinking moonshine in a trailer in Tishomingo County, Mississippi, when things got out of hand. Tale as old as time, song as old as rhyme, American pastimes can't be beat. And pursuant to Brian Berryman's signed written statement he later gave police, Berryman, his neighbor David Thacker, and David's girlfriend were drinking moonshine in Thacker's trailer when Tracker asked to borrow a DVD from Berryman, which Berryman refused.
I love that. Who borrows DVDs anymore? But apparently this guy did.
Right? And I miss digital, physical, I guess not digital, but physical media, right? Now I wish that I could have a Blu-ray DVD sold to me and shoved in my face, but there were no details on what movie it was, which I feel like is super relevant. Is it not? Are we getting into a gunfight over Shrek? Is it A Few Good Men? Is it Shawshank Redemption? I would like to judge the caliber of movie that is worth a shootout. That's just me. Thacker then struck Berryman in the face about 3 times. Berryman then grabbed his .22 caliber rifle and a .380 caliber pistol and drove to the trailer to scare Thacker by shooting his rifle 3 or 4 times into Thacker's bedroom. Thacker called the police. The police show up to basically a scene where the girlfriend and David said he shot through our trailer. There were several bullet holes in the trailer, in the living room, through the doors. They went 2 houses down to Berryman's house. Berryman's face was bloody. He clearly looked like he'd been beaten up, and he consented to a search, which you shouldn't do if you you just shouldn't do.
Yeah,
if you, I'm like, just don't do it. Under the advice of any lawyer with a pulse, don't consent to a search. Make them get a warrant. But neither here nor there. He consented. The search revealed 2 firearms, a .380 caliber pistol, the .22 caliber rifle, ammunition for both hydrocodone and oxycodone. Now, at the time of his arrest, Berryman was already in violation of his parole from a life sentence for a 2009 conviction for capital murder with an outstanding warrant for his arrest. As a result of this 2017 arrest, his parole was revoked and he remained in the state's custody until trial, which would not take place for 1,233 days, which is 3 years, 4 months, and about 10 days. That is obscene for even these are low-level crimes. They just really are. This should not have been needed that much time to adjudicate. And indeed, the reasons for the delays were described as a, quote, comedy of issues by the lower court and, again, repeated by the Fifth Circuit here. Now, chronologically, those issues are as follows. Berryman, arrested February 2017, not indicted until 7 months later. On September 22nd, 2017, my sister's birthday, happy birthday to her. She won't listen to this. She doesn't care about law. A grand jury finally indicts Berryman for a violation of both of these counts. Count 1, shooting into a dwelling. Count 2, possession of a firearm subsequent to a sustaining felony conviction. Now, ultimately, the trial court, the trial court would dismiss his indictment for speedy trial violations as to the first count, shooting into a dwelling, but then left the second count, possession of a firearm, stand. He wasn't arraigned. After he was indicted, he was not arraigned for another 14 months. So now we are at November 7th, 2018. Because his name was negligently left off of the arraignment list. That's the only reason why. Those are the reasons the state is admitting to, saying, yep, this is the best reason we have, the best excuse we have in our bank.
We forgot about this guy just sitting in jail.
Right. Our bad. Sorry. Marshall Edge, a witness expected to testify in Berryman's defense, died during this delay. So we are presently at around almost 2 years now. During this 14 months plus 7 months delay, 21-month period, Berryman files 2 pro se motions seeking an appointment of counsel and 2 dismissal based on denial of a right to a speedy trial. At arraignment on November 7th, 2018, he was appointed counsel finally, but the attorney was immediately disqualified because he had been elected to circuit court the previous day. My word. What are we doing? On November 21st, 2018, Berryman filed a 3rd pro se motion requesting a trial, dismissal of indictment, and appointment of counsel. Now, I just completely scrolled. Just give me 1 second. Oh my God. Okay, here we go. Here we go. But on January 7th, 2019, so a few months later, after the new year, all right, we can't do any work November to January. Sorry, guys. Thanks for filing in November. We'll see you next year.
You got to wait for the new term. It's kind of like the courts in the old days.
Everyone's on vacation, okay? Everyone's having holiday parties. You can sit in jail. So sorry. The court appointed Berryman a second attorney, but the order was never filed due to a clerical error. So Berryman was never informed of this appointment. He never knew that he had a lawyer. Further, the second attorney also had a conflict because he was the district attorney who previously prosecuted Berryman for capital murder. The fact that he would even be considered at any point as the name we put in place on a blank line is obscene. The second attorney informed a third attorney that he would need to take over as Berryman's counsel. Berryman, however, was not informed. So this is now the second lawyer he's had that he had no clue, not a clue in the world. Thriving, Berryman filed his 4th pro se motion for a speedy trial on April 18th, 2019. Now, completely aside, the presence of mind for him to be doing all of this completely on his own and to be making the correct arguments and filing to whatever quality and effect, right, these motions is he should get points for that because the fact that he even knew to do this, it's incredibly impressive. Despite the fact that, right, speedy trial motions are rarely granted, blah, blah, blah. Speedy trial motions filed by attorneys are also rarely granted. This is filed by him. I am very impressed. On June 21st, 2019, the court entered a continuance order signed by the third attorney, purportedly on behalf of Berryman, but, quote, without his consent. Berryman tried to appeal the continuance, but the appeal was dismissed for lack of an appealable final judgment in October 2019. Berryman filed another pro se motion seeking dismissal on grounds that his right to a speedy trial had been violated. Between September 2019 to April 2020, the assigned trial judge was unavailable, and a second trial judge entered an order that canceled the January 2020 term of court for Tishomingo County. Berryman filed a motion requesting that the second judge recuse himself since he had previously prosecuted Berryman for robbery. The motion was granted. At this point, we're coming on past 3 years. I'm getting whiplash, truly whiplash. A third trial judge ruled on some of Berryman's pro se motions, including the appointment of counsel on March 16, 2020, in COVID, now at this point, after he was arrested in 2017, February of 2017. Now he's in custody during COVID. What else can he do but research how to file these motions? Because Berryman had been provided appointed counsel, quote, since his arraignment, but there was no actual order on the record, the judge entered an order appointing the third attorney. In April 2020, Berryman filed a mandamus petition requesting that the Mississippi Supreme Court order the trial court to rule on his October 2019 motion to dismiss. The trial court set a hearing, and the Mississippi Supreme Court dismissed the mandamus petition. Days before the hearing, the trial court appointed Berryman a fourth attorney, as the third attorney was elected to the Mississippi Senate. He has a motion to dismiss hearing. He basically argues that his right to a speedy trial had been violated because there were too many continuances and he had lost a defense witness in the process. He claimed that this man who had passed away, Edge, would have testified that Berryman did not have a gun When he walked to Thacker's trailer the second time, he further asserted that his signatures on the waiver of his rights and written statement he gave to police when he was arrested weren't actually his signatures because they misspelled his name as Bryan instead of Brian. A variety of issues, okay? So finally, the analysis of the speedy trial claim finally comes to fruition. The state court decides that there is a speedy trial violation for count 1, but not for count 2, which in the context of speedy trial violations, the balancing test of Barker versus Wingo, a 1972 Supreme Court case, is applied. Now, 4 factors are length of delay, reason for the delay, defendant's assertion of the right, and the prejudice to the defendant. For whatever reason, definitely not a precedential reason, the trial court weighed the first 3 factors as all the same for both counts. But then the 4th factor for prejudice, they weighed it differently for each count. They say, okay, which count is going to be more or less prejudiced by this? Which, under Supreme Court precedent, speedy trial precedent, you don't do. They don't know where they got that from, but they got it and they applied it. So they dismiss count 1, they keep count 2. He is convicted, and ultimately, after a variety of procedural mumbo-jumbo, he files his habeas petition, denied at the district court level, goes up to the Fifth Circuit, and the Fifth Circuit not only said, yeah, trial was less than speedy here, we're going to dismiss the entire indictment, because nowhere in Supreme Court precedent does it say it's dismissal of the count instead of dismissal of the entire indictment.
Yeah, you get the sense that the state trial court judge was probably just splitting the baby and like, well, this one's more serious than this one. We'll just go half and send it to trial. Right.
Which I don't know. They do that a la carte pretty often. Mm-hmm. I feel, especially when, a lot of these defendants don't understand timely appellate processes and how they work, and they never appeal on time. And then these orders stand.
So, Bobbi, your thoughts about this escapade, which, it finally resolved. Well, we hope it's resolved here in 2025. But basically, this was 8 years of this guy's life.
I mean, it's insane that denial of a constitutional right can be boiled down to a comedy of issues. That's just an insane way to put it. I think this was the right call by the Fifth Circuit, but the interesting thing to me was the witness was going to testify that he did not have the gun when he supposedly shot into the trailer. So that's count 1. The witness passed away before he was ever arraigned, I believe. So the majority of the delay would have been prejudiced anyway against count 2. And I think it was, I would love to know, why they decided, okay, we'll dismiss count 1. We're going to keep count 2 because, the delay was there regardless.
Yeah, I'm not sure. And then the wild thing to me is Judge Ramirez still dissents and just says I think essentially what he's saying is that the Supreme Court precedent isn't clear. It's actually a little ambiguous as to whether you drop both counts. I still don't get how you could, if you have waited this long, why one count would be prejudicial and one would not when you're being prosecuted for the same thing.
Further, it's not as if the facts of each count are different. The counts of the indictment are all based upon the same set of circumstances, the same sequence of events. The idea that it's vague or the law is not clear in dissents like that, I went through Judge's dissent, and it's just not sound in law or precedent. We put a lot of emphasis, rightfully so, on language. If the Barker court in 1972 had intended it to be a count-by-count analysis, they would have said that. Instead, it's a case-by-case analysis, and quote-unquote, as the Fifth Circuit repeated and quoted, bold and italics so many times, the remedy for a speedy trial right violation is dismissal of the indictment, period. That is the remedy. It doesn't say dismissal, period, right? Because then what does that mean? Dismissal of what? Dismissal of the indictment. If they had wanted it to be by count, they would have said dismissal of the count.
Yeah. I think, and putting all the facts in this case together, it's a reminder, because it is rare, right, that we have especially on habeas, that we have a speedy trial win, as you were saying, Reb, for the defendant. It's a reminder that, often there are huge delays from arrest to trial, but usually most of that is waived because the defense attorney is trying to, either cut a deal or doing what he can to just move the case along, and so the ability to object to that just doesn't arise. It's when something just incredibly wild happens and you're not told about your attorneys and they keep getting removed to higher office that you even have a shot at a speedy trial violation. And yet these kinds of delays happen a lot, especially in pretrial detention.
Happen a lot, and often happen with defendants who don't know their rights and who aren't at least legally sound enough, which I don't, if you would have told me before law school, hey, you should probably file a motion while you're sitting in prison right now, hurry within the time required, pro se, motion to dismiss indictment for a speedy trial, I probably wouldn't have figured that out. It would have been too late in the game. The fact that this happens to defendants who aren't so cognizant of their rights and what arguments to make before, you aren't able to raise them on appeal anymore, that it's absurd. It's truly absurd. And I think more speedy trial violations should probably be found in circumstances like similar to this, but we never see on the docket because they never get challenged.
Right.
Well,
And
in this case,
Bobbi.
Sorry, this case is interesting too because reading this opinion, I started to feel a lot of sympathy for Brian Berryman, and he's a murderer out on parole, and it's just it just goes to show, like, even murderers out on parole get constitutional rights, and that's just not something that a lot of people would think of. He deserves a speedy trial just as much as anyone else.
Our friend Andrew Fleischman, which some listeners be familiar with, he's a criminal defense lawyer in Atlanta. He recently had a matter where there was a man. I think he found a man who had been in pretrial detention in Georgia for 10 years. Now, it was on a very serious crime, and maybe the guy was innocent, maybe not, but he was able to eventually get him out on speedy trial grounds, but it's just forgotten about, right, by society, by especially by the system. So,
well, did you know? Just a fun fact: we are top. If not, it's like we're either number one or number two, I think, as of this year, of the mass incarceration population in the world. And right now, as we sit here, 2 million people in America are incarcerated in federal and state prisons and jails. And out of those 2 million people, 470,000 have not been convicted for the crime for which they are put in jail for, because of pre-trial detention, because they cannot make bail, because they were not granted bail. And so many of these indictments are for non-violent offenses, are for offenses that have no business keeping you behind bars just to see whether we can convict you or not. These are people who are innocent until proven guilty, and the rampant nature of pretrial detention and of the for-profit jail and prison system that we have absolutely contributes to the injustice that not only victims feel, but people who are incarcerated feel. They deserve justice just the same.
Absolutely, and we all forget about the little words of the Eighth Amendment. Excessive bail shall not be required, and that means that you should be able to make your bail or whatever it is and get out while you're waiting for your trial. And yet in some jurisdictions, it sounds like Mississippi, it's actually the opposite. It's expected you're going to be in pretrial unless you're special, I guess. Well, we're going to now look at actual detention and forfeiture associated with that actual detention from the Second Circuit, and that's Bobbi's case. Now, this case has to do with criminal forfeiture. Now, we talk a lot on Short Circuit and IJ about civil forfeiture. Criminal forfeiture is when you're actually convicted, and then there are criminal things that happen to you because you did those bad things. And yet, they are kind of related in some ways in the law, and in a way that I frankly got super confused in reading this case. So maybe Bobbi's going to straighten me out.
I'm going to try. So this is United States versus Elias. It's out of the Second Circuit, and it was decided on October 8th of this year. So as Anthony said, this is a case about criminal forfeiture and exactly how far a criminal forfeiture order can go. If you're familiar with Short Circuit or IJ, you know we do a lot of work around civil forfeiture. Criminal forfeiture is a little different. So before we get into the facts, I kind of just want to explain the difference and how sometimes they overlap. So in civil forfeiture, government brings an in rem action against the property itself to seize property connected to a crime, really regardless of the culpability of the property's owner. Criminal forfeiture, by contrast, is only imposed upon convicted defendants to confiscate assets gained from serious crimes. It's meant to ensure, as the court says in Elias, it's meant to ensure that crime doesn't pay. It's an additional sanction at sentencing. And so for a robbery, for example, you're sentenced to prison time, but you also could be sentenced to forfeit the proceeds of the robbery. And forfeiture is a creation of statute. So the government can only enter a forfeiture order against a defendant if the criminal statute permits it. So our defendant, Matthew Elias, he was involved in a robbery of a stash house in Queens, New York in September of 2017. A group of defendants broke into the house from a second-story balcony, beat up and restrained the gentleman inside, and stole a safe and some marijuana. So it's important to note that throughout all of this, Elias never entered the house. He was in the getaway car, and he was just waiting for his co-conspirators to come out. At some point, the group gets split up. They had taken 2 cars, and they were all supposed to meet back at this house on Galway Avenue, which the court refers to as the Galway House, to presumably divide up the spoils of their little adventure. But Elias...
Well, wasn't it they had a tip that there was like supposed to be $400,000 in this house, but they do the robbery, but it's not as remunerative.
You're right. That is why they went to the house. The ringleader, Mr. Hytmiah, got a tip that there was $400,000 in this house. But as we'll see, the group splits up. Elias takes one car to a different house, and then Mr. Hytmiah takes the other defendants to the Galway house, where they crack open the safe. They find a measly $20,000 and a firearm. But Elias and his group, they have the marijuana. When Mr. Hytmiah learns that this other group is somewhere with the marijuana, he starts to get concerned that maybe they're going to keep it for themselves. So they go find them. They're all together. Mr. Hytmiah steals the marijuana and orders everyone back to the Galway house. On the way back to the Galway house, of course, now this is comedy, Elias gets pulled over for rolling through a stop sign. So he and everyone in his car are arrested. He's charged with robbery under the Hobbs Act and unlawful use of a firearm. Eventually, 17 defendants in total are charged as part of this with a variety of weapons, robbery, and racketeering charges. So it looks like this was a pretty large operation, and Elias played a relatively small part. Nonetheless, he was found guilty for his part in the robbery. He was sentenced to 120 months, so 10 years in prison, and ordered to forfeit $10,000. And I found it interesting, the ringleader of this, Mr. Hytmiah, was the chief witness for the prosecution in Mr. Elias's trial.
Yeah, you wonder what kind
Isn't that always how it shakes out? My goodness.
Crime doesn't pay. It really... So Elias appeals several aspects of his conviction, but it's the forfeiture order that this case focuses on, so that's what we're gonna talk about today. So I mentioned earlier that forfeiture is a creation of statute, and Elias's forfeiture was based on 18 U.S.C. Section 981, which is actually the civil forfeiture statute, and 18 U.S.C. 2461, which is the Hobbs Act robbery statute, because that statute basically authorizes a criminal forfeiture in any case where a civil forfeiture would also apply, which does apply to robbery. So those two statutes taken together basically say that for specified unlawful activity, including robbery, the government can order a criminal forfeiture for, the assets that were obtained as part of the crime. And that word obtained becomes important later. Elias is ordered to forfeit $10,000 because that's what the court determined was his share of the the spoils of the robbery. But because he was arrested, he didn't actually get any of the money at any point. The case actually says that Mr. Hytmiah kept all but $500. And when Elias, in a recorded jail cell call, asked one of his co-conspirators when he could expect to see some money, he was told, "You will get," and I quote, "no cut of that expletive." So Elias says, hey, I can't be made to forfeit proceeds that I don't have. I never actually got.
And also, Bobbi, whoa, you are discrediting Hytmiah. He kept everything except for $500 and a pound of marijuana.
That is true.
He so graciously gave to Darby, who is, again, not even the man that they are trying to get the proceeds from, in this case, Elias. He gave it to Darby.
Right.
So, look, he's not completely selfish.
Right.
He's just a little selfish.
I don't know. Maybe if there was actually $400,000 in the house, as they thought, maybe Elias would get a cut. But no, I mean, he will get none of that.
How much pot was in the house? Like pounds?
So I don't know. I'm not an expert on valuing marijuana. However, if 17 defendants were arrested and his cut was $10,000, I would assume it was probably a lot. You know,
in the year of our Lord 2025, discussing marijuana charges, I mean, obviously armed robbery is another completely other situation, but it does make it a little less serious when you start getting into, there was marijuana and this and that and the other thing, and you think there are people in Colorado doing startups absolutely selling marijuana out of their basements and everything's fine for a lot more than this. Right. So obviously it doesn't lessen the severity of this crime whatsoever, but when we're splitting hairs by, how much was the marijuana cost? I mean, come on. Yeah. Gosh, he didn't get any. That's the point.
He got no cut. He got no cut of that. So Elias relies on a Supreme Court case, Honeycutt versus United States, for the proposition that if property or proceeds of a crime aren't actually acquired by the defendant, then that defendant can't be made to forfeit them. And so I'm just going to talk about Honeycutt for a little bit because it's kind of similar. In Honeycutt, the government brought charges against these two brothers who ran a hardware store because they were selling an inordinary amount of this chemical that is a water purifier, but also can be used to make meth. And they were selling more than any layperson should need. They were charged with and convicted on federal narcotics charges, and they were basically ordered to forfeit or disgorge the store's profits. Now, the one brother, Terry Honeycutt, says, "Hey, I'm just a salaried employee. I didn't get any of those profits. My brother Tony, he kept it all." And the Supreme Court basically agrees and says that since Terry Honeycutt didn't actually keep any of the profits, that he can't be made to forfeit something that he didn't keep. It was not money obtained as a result of the crime. Under no definition of obtain, be it the dictionary definition or the common usage of the word, can that apply to property that was gotten kept by someone else. So Elias looks at the result in Honeycutt and basically wants the same result. He says, I didn't get a cut. I shouldn't have to forfeit what I didn't obtain. The problem for Elias is that the Honeycutt's forfeiture order was made pursuant to a different statute, Section 853. And there was no case yet in the Second Circuit that had applied Section 1853 to forfeitures under Section 981, like Elias's. And the other circuits to address the issue were split. On one side, you had the Sixth and the Eighth Circuits, and they say that Honeycutt's rationale only applies to Honeycutt's statute. We're not going to extend it further. The statutes aren't similar enough, and they just don't think that the same rationale should apply. On the other hand, you have the Third and the Ninth Circuits, and they read the two statutes to be substantially the same, and they're willing to extend the ruling of Honeycutt to forfeitures under Section 981. And they limit forfeitures under Section 981 to property that the defendant actually obtained. And they focus a lot on that word obtained, and that's very persuasive to the Second Circuit here. The Second Circuit ends up agreeing with the Third and the Ninth. They spend a great deal of time on both statutes and kind of looking at the language, the wording, and both statutes use this word obtain. And like we talked about before, it makes no sense to require an individual to forfeit property that they never actually had in their possession.
Yeah, that's a fine.
Right.
Maybe you could do it, but it's not a forfeiture.
And
to me,
it makes sense when you think about the rationale behind forfeiture, behind criminal forfeiture statutes especially. They're punitive. They're to punish. They're to make sure that you don't gain anything from your unlawful activity. And Elias didn't gain anything from this night of fun in Queens, New York. So it's not the intent of the forfeiture statutes to make him pay back any money. So this is still a circuit split. The Second Circuit just kind of deepened it a little bit. So we'll see what happens in the future if the Supreme Court wants to say anything about it. But just like Mr. Berryman, I felt a lot of sympathy for Matthew Elias reading this opinion. He's this low-level guy in this supposedly big racketeering operation, and he's in jail for 10 years for driving a car.
And I would argue that these type of criminal forfeiture statutes, seem punitive, but the way you read them, it's just plain restitution. You're giving back what you took and no more than that. They're not if you charged everyone who engaged in some type of crime where they steal either property or something of value or money outright, if you required all of them to pay back exactly the value of whatever the crime was that they were involved in, whether they got, again, a single hit from a joint or the entire stash of marijuana, it would just lead everyone who, I guess, remains in prison for failure to pay. It would just be debtors' prisons. That's all it would be for everyone who's involved in these type of schemes. If you already got the money back, ask your lead witness. Or if you think that you don't have all the money back, ask your lead witness. Was there more information about whether he was required to pay?
I did try to find that. I don't see that he was charged at all. So I think... I don't know, but I think he probably kept it all, and he probably put all these other guys in jail.
Wow. Well, that ending on a happy note.
Very successful ringleader in that way.
Right. Listen, the great line of work, apparently. Goodness.
Yeah, it seems that the government's position, or what the courts that have gone the other way here, it kind of mixing together. So on one side we have forfeiture, where you have to have something to forfeit it, and the other side you have conspiracy law, right? So everyone in the conspiracy is involved. So even, right, I'm just the driver. We've all heard that before, and yet they still are booked with the same stuff that is the rest of the conspiracy. Same with the felony murder rule, where I was involved in the robbery, but I wasn't the one who shot the gun. Well, sorry, felony murder. Mm-hmm. And so that's kind of infecting here, or the government's trying to have it infect the forfeiture rule, which is common sense. I have property, I don't have property.
Right.
Mm-hmm. I think the public policy, purpose of this is definitely more attained, or more justified through this circuit's opinion than the other circuit's reasoning. Because if the point of it is just to get back to basically say crime doesn't pay, period, it would make no sense if we're requiring people who quite literally do not have any of the funds you're talking about to pay. When the rationale for felony murder, for example, we had a very famous one years back, a police chase where the police were negligent in their operation of a helicopter. The helicopter crashed, killed everyone on board. The person who was trying to get away from police over, a minor drug violation was charged with felony murder for all these people. The public policy rationale for it is to dissuade people from engaging in acts that would lead to a felony murder involving police situation, right? Hey, maybe don't run from the police. That's, I guess, the rationale, right? If you don't run from police, then you won't be charged with murder if one of the police officers is negligent and doesn't know how to drive a helicopter, right? That's how you solve this. In this scenario, it's basically be the ringleader. That's what we're telling. That's the message that we're sending if we go the other circuit's way, in my opinion.
You got to start at the top. Don't just be the driver like this guy.
Yeah, exactly. Work your way up, upper management.
Right, because what's the logical outcome here? This forfeiture stands. He's got to pay it back with as yet to be earned money, hopefully legally, and then that becomes money that's not at all tainted by crime. So the public policy is not served by allowing this forfeiture to stand. I agree.
Right.
Mm-hmm.
Well, Bobbi, thank you for that tale from Queens, and makes me intrigued about all kinds of other things to do with that case. But maybe I'll look that up some other time. So, Reb, before we go, you want to tell us more about how people can find you, how they can get more of your stuff, or maybe whet their appetite about the book coming out later?
Yeah, so I am on all social media. I'm on Instagram, I'm on TikTok at Reb Masel, RebMasel. I have a podcast called Rebuttal Podcast. You can find it on YouTube, Spotify, and Apple Podcasts, where I talk about crazy cases or wild cases or funny cases or absurd cases in the law that law students might not even know about. So if you are a lawyer or law student, you can check it out. Maybe you'll learn a little something. I have a book coming out called The Book They Throw at You, A Sarcastic Lawyer's Guide to the Unholy Chaos of Our Legal System. That will come out next year, and I'm really excited about it.
But you didn't read the asterisks.
Oh, yes. God, no, not actual legal advice. That's the asterisk, of course, which is, as all lawyers have been told since the beginning of law school, is very important to remind people of. And yeah, it's basically just a collection of kind of like the format of it is a bit like Chicken Soup for the Soul books are formatted, where it's just a compilation of a lot of different stories or cases or narratives from different parts of the law, the legal profession. It varies between really hilarious and really informative and interesting, but short and sweet and to the point. And if you are not a lawyer, you'll hopefully love it. And if you are a lawyer, it'll be your Bible.
Well, great. Well, we look forward to the next edition of the Bible. We always like that, and we like having a book here on Short Circuit now and then. So thanks so much for coming on, Reb. We really appreciate it, and we'll put a link in the show notes to all of your platforms, but I'm sure people can find that too. Thank you also, Bobbi, for coming on, and to everyone else. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.